Hey everybody, welcome back to Realtime Immigration. I'm really happy to be joined today by Lori Bruun. Lori is a longtime veteran at USCIS. She recently left the agency and is now out in the private sector with the rest of us. And I'm really excited today to talk with her about her career at USCIS and sort of how her experiences can provide a lot of really deep insight into what a lot of the practitioners who listen to this podcast are dealing with right now with their clients. So, Lori, thank you so much for joining me today. I'd love to just sort of kick things off by giving you the floor to talk about your career at USCIS because you held many different positions, you were in different leadership roles, and I would love for you to just sort of walk the audience through your experience from when you started to when you recently left the agency.
Great. Well, happy to be here. So I started back in 94, November 94. I was hired temporarily to work on legalization appeals, actually, the Special Agricultural Worker Program. And while I was there, I got detailed to the Baltimore District Office, and then they were able to pick me up permanently. So at the Baltimore District Office, I was working on adjustment and naturalization applications, and so that was really great way to interact with the public, and I enjoyed that work. Then I came back to the administrative appeals office on the AAU side because it was separated from legalization at the time. So I came back there, and then I started working. But initially there I was working almost entirely EB-5 because this was like 2001. So the precedent decisions had come out in 98. There was a big backlog at the AAO. So I took care of that. And then I moved on into also doing NIWs and E11s and E12s, the outstanding researchers. I also worked on, I did some labor cert cases as well. I also did O's and P's while I was there. So I was there all the way until 2018. In 2018, I moved to the Office of Policy and Strategy at USCIS, and I was in the Business and Foreign Worker Division there. And my portfolios were EB-5. I've been sticking with EB-5 all the way since 2001, so I'm very familiar with them. But also, working with E11s, E12s, national interest waivers, all I-140s really, and O's and P's as well, and Q's if anybody wants to talk about Q's, but also
Sm-
those and religious workers.
Much smaller niche on the cues, but I'm sure
Yes,
I'm sure
very much so.
there's an audience out there, no doubt.
Right.
Um, it's such a robust body of work, and there's so many different angles we could go into in this podcast, and we would need much more time than we currently have. So maybe we'll make this a multi-parter. But what I really want to focus on to start is your time in the Office of Policy and Strategy, because I think for most immigration practitioners, they know that USCIS has that office. They know that when like a notice of proposed rulemaking comes out or a new reg or an update to the policy manual, like that there's a team of folks like you at USCIS who were tasked with putting those together in the first place, and then seeing them through to implementation. But I'm wondering if you could maybe give us like a little bit more of a behind the scenes look at like what your day looked like working in that office, and some examples of some of the rules or the changes that you worked on in your 7 or so years as part of that office.
Sure, sure, absolutely. So it kind of varied how issues would come to our attention. There's a couple of different ways. Leadership could say, "Hey, this is something that we want rulemaking on this." Sometimes it's congressional, right? With the H2s, right? When the H2Bs, when more visas need to be made available, like that's got to be a reg. That's from Congress. That's something that we have to do. So sometimes it comes from there. Um, the but sometimes it'll come from the field. We would have monthly meetings with the field with SCOPS, and they would say, "Hey, our officers are seeing this. They're really struggling with this issue. This is a new issue. There's nothing in the policy manual about it. They don't know what to do. They've asked for legal advice from the attorneys, and their attorneys will say, well, this is kind of a policy call." So then we would have meetings about it. We'd bring in our leadership, and we would try and find something for the policy manual to address that issue. So, we had a lot of meetings. and a lot of drafting. OP&S, I was always a big proponent of the policy manual when I was there because they have OP&S has a team dedicated to the policy manual. Like, they're not subject matter experts; they're experts on policy manual, how the style of it, the word, the plain language needs of it, the organization of it, and they review everything that gets published in the policy manual once the subject matter experts have finished it. And I take my hat off to them all the time, because if you read the policy manual, it reads like one person wrote it. Whereas you look back at the AFM and it's like, oh my God, 8 million people wrote this. So, like, it's all over the place. And the policy manual is really, I think, much better and much clearer, and it has links, and it's just it's a wonderful resource. So I was always happy to work with the policy manual team on those issues. And, we would also have, policy would come down from the administration. There were certainly different policies on H-1Bs in the first Trump administration. And then in the Biden administration, there was lots of interest in STEM researchers, and, how can we make it clear to them what they're eligible for and what they're not? And so, those kinds of things would come down to us, and we would try and come up with policy that would clarify that. I mean, obviously, our preference and the preference of our lawyers was always, well, really, this should be a rule. And we'd be like, that's nice, but that has to go through DHS, and DHS does not have they don't have the manpower to just review every rule we send over there that we would like to publish. So, not everything could be a rule that we would like to be a rule, but, we always made the point that this would be better in rulemaking.
Yeah, absolutely. And I think with this new Trump administration, which you were at USCIS for part of the new Trump administration, there's been a very ambitious, I think, regulatory and policy agenda in terms of right off the bat, it was noticed by practitioners that a lot of stuff that was in the policy manual during the Biden administration was pulled out, some without like explicit notice. It just one day it wasn't there anymore. And of course there's a lot of notice of proposed rulemakings that have been sitting on the back burner for the last 12 months. Some are expected to come out in 2026, one on I-140s, specifically around EB-1s and EB-2s we'll talk about a little bit later. But others that, we have seen movement on the weighted lottery rule, right? For example, which we saw originally come out in the summer, final rule came out around Christmas, and now USCIS is obviously pushing ahead with that one quite quickly to have it ready for the lottery here in 45 days or so, less. So I guess like in your experience and you can talk about maybe this Trump administration, you could talk about the first Trump administration, you can talk about the Biden administration too. Um, how were priorities set for your office and policy and strategy? Because you mentioned a few different ways that things could come up. There was bottom up, there was top down, there was a backlog of policies that needed to be managed and were sort of ongoing sagas. So yeah, how were priorities set, like on a monthly or quarterly basis at a high level?
So there's a division in OP&S specifically for regulatory actions,
Uh,
and they would set the priorities for the regulations that were, the ones that were top tier that, definitely wanted to get done. And then the ones that, well, you can work on them if you want to, but, there's no guarantee anybody's going to look at them. So, and they're the team who have the economists. When you engage in rulemaking, the economists really have to spend a lot of time drafting the economic impacts of these rules, and that's a lot of work. And there's only so many economists at OP&S, so that division really, and they really work with USCIS leadership to develop, what are the rulemaking that we only have. Our economists can only work on this many regs,
right.
so they would have to go to USCIS leadership and say, well, given that this is the amount of regs that we can work on, what regs do you want us to work on? And so that's really where that would come from in setting the priorities of the agency. The policy manual was a little looser because there's a little less resources required to update the policy manual, but we definitely needed leadership buy-in for updating the policy manual.
In your experience, and I know you can only speak to this so much, obviously, now that you've left, but like, what were some of the main priorities of this Trump administration coming in when it came to policy changes? And do you think that the top level priorities for them have already had action taken on them on either the policy, or excuse me, either the policy manual or in the rulemaking process, or do you think that there are more priorities that are sort of yet to come around the business, corporate, high skilled immigration space?
I mean, that's a really good question. I think, a lot of and this you saw in the last Trump administration as well, the big priority for them is H-1Bs. And so, that was really, I never worked H-1Bs. I always used to joke, I do EB-5, so I don't have to touch the H-1Bs. So, but I mean, you definitely see, my colleagues in DFWD absolutely worked H-1Bs. We had weekly meetings. I knew what was going on with H-1Bs. So definitely you saw there's a lot of focus on H-1Bs, and you've seen some rulemaking already come out with respect to the H-1Bs. The registration process has changed, but the weighting has changed based on salary and degrees. So those kind of changes I think you've seen. I think it's yet to be seen where that's going to happen with the green card classifications, because certainly we expressed interest when the new administration came in, and we said, hey, you know what we want to know, what do you see the national interest waiver? And before I left, we didn't really get much of an answer on that. So it's hard to say what. I'm sure they'll turn their attention to it, but they hadn't turned their attention to it when I left. Some things that they've acted quickly on, which is interesting to me. They just came out and with the R1 fix, which is, after State Department changed how the EB-4s were allocated, all of a sudden, the EB-4s were going to be waiting longer than they could stay in an R visa for the religious workers, that is. And
Yeah.
that was a huge issue for religious workers. They've now changed it that there's no set time that they have to be outside of the United States for after 5 years in the United States where they can renew their R. So that is a huge help to them and the religious worker community. So that was an issue that was percolating that we were very much aware of when I was there. So I was glad to see the Trump administration finally acted on that and did something about that. I was a little surprised to see they just did it with an interim final rule that only addressed that, because we were trying to figure out where else to put it. What other rulemaking are we doing that we can add this on to? They were like,
Yeah.
forget it. Here, it's just an interim rule with just this issue. It's like, oh, okay, that's one way to do it too. So
Which has certainly been one of their strategies.
yeah.
Is that they do like the interim final rule announced with like very little notice of when its implementation date is. Which I get it for some reasons. It kind of segues me into my next question. You obviously were a career civil servant at USCIS. You served under several different administrations, Republican, Democrat, when the definition of Republican and Democrat have meant different things over that time period too. Um, and I'm curious because the current chief of the Office of Policy and Strategy is a political appointee at the moment. I'm not sure if that's always the case. You can tell me if it is or not, but he's a political appointee. He was a guy who worked at an organization called Numbers USA for many years, which is a sort of an immigration restrictionist advocacy group. They believe in lower immigration overall, and he's now, as of August, leading that office. How much sort of power and resources and energy do the political motivations or agenda of USCIS leadership drive what actually happens in your experience versus, right, there are bipartisan might not be the right word, but just like structural, you know, challenges that USCIS faces as they're trying to figure out how to navigate a 30-year-old immigration law that hasn't been updated by Congress but needs to be interpreted for the modern world. How much of it is just dealing with like the same issues that, regardless of administration, USCIS knows it needs to deal with, versus like the political priorities of the new administration that comes in each time?
So I would say that the chief of OP&S has been political since I joined in 2018. So if that was the case before then, I would imagine it is. But
Mhm.
I know definitely it certainly has been, and that definitely shapes what issues we are interested in. We had people from when we had people from that had used to work for, you know, for senators who were very interested in EB-5. When they came and they were involved with OP&S, some of the OP&S became very interested in EB-5. We managed to get a regulation out. It was knocked out because the wrong, the secretary who signed it, the court said they didn't have the authority to sign it. So
Oh yeah,
that rule died. But, you definitely see that, the priorities of the policy chief definitely that drives what OP&S works on for sure. And,
yeah.
I mean, I'm sure that's always the case, and political leadership is always going to drive the priorities of any agency.
Yeah, I asked that question because I was sort of trying to set up this one, which is so at Lawfully, obviously, you've seen our data. We track adjudication trends in real time from USCIS, and so we've seen that through December, we track 23 employment-based case types. 20 of them, the trends have been exactly the same for all of 2025 as they were in 2024, 2023, 2022 during the Biden administration, which is approval rates have been quite high for H-1Bs, for Ls, for Os, although we're seeing a little bit of a dip there, which we'll talk about a little bit later. For most of the I-140 classifications, other than EB-1A and EB-2 NIW, which we'll talk about again in a minute, and RFU rates have stayed like pretty low. Whereas during the first Trump administration, RFU rates for H-1Bs, for example, skyrocketed to as high as 60% in the first year,
Oh
right?
my goodness.
And there was sort of more volatility in that first year. For the most part, like this administration has come in, there's been a lot of rhetoric around high skilled immigration and higher scrutiny, but in the adjudication trends, we haven't seen a lot of that, with the exception again of EB-1A and EB-2 NIW. But I think and could be sort of what we talk about next. Like, and let me just share a chart for those who are watching this podcast, not just listening. Um, I think that also the factors that have gone into heightened scrutiny for EB1A and EB2 NIW are related to the fact that the demand has increased exponentially over the last 5 years. So the dark blue line for folks who are watching basically shows the number of quarterly USCIS receipts for EB2 NIW I-140s in government quarter Q4 in 2021. There were 5,000 received. In Q4 of 2024, it was over 20,000 in one quarter. So, 4xed over the course of a few years. It's gone down a little bit, but quarter over quarter, year over year, USCIS has received substantially more EB2 NIWs, quite a few more EB1As, and now more O1s as well. So, Lori, maybe you can talk about just your time at USCIS as a whole, but also in the Office of Policy and Strategy. When all of a sudden these classifications, the demand for them skyrocketed, what were the internal conversations like at USCIS in terms of like, hey, what's causing this increase, and also how are we adjudicating petitions? What information are we giving to adjudicators and folks who are being trained on adjudicating these petition types for what actually qualifies an applicant for these types of cases? Because there's so many more who are applying than there were, a few years before.
Sure. I mean, that's a really interesting question. I think, if you take the NIWs, right, if you go, and I think it's important to go a little bit all the way back to what happened at the end of the Obama administration when they replaced NISDOT with DANISAR. And
Mhm.
then after that, there was no time to update the AFM for that. So this precedent decision came out that wiped out, what was in the AFM that was in NISDOT. And so there was this new way to look at those cases. And then the Trump administration came in, and at that time we were moving AFM content over to the policy manual. And it was a huge undertaking to move over the I-140 content because we were talking about at least 8 benefits within the I-140s alone. And so getting all of that, figuring out how to organize it, how to structure it and move it over. And then what do we do with the NIWs? Because nothing that was, because at the time it was just it was just a conversion, right? We weren't
Right.
trying to set new policy. We were just moving stuff over, but we couldn't move over the NISDOT material because NISDOT was no longer. So all we did was we were just like, there's this Danisar, and here's what like a few sentences about Danisar in the test. And that was it. There was no policy about Danisar that went into the policy manual. So there was a lot of confusion, I think. And so I don't know, I'm not entirely sure how SCOPS was training on Danisar at the time, but there was nothing in the policy manual. So then fast forward to when the Biden administration came in, and they were like, well, they really, it's not enough. We need to explain to people how to use Danisar. So, and, we spent a lot of time working on how that would be. And so in January of 2022, we issued a lot of guidance on how to adjudicate under Danisar. And once we did that, then I think if you look after that, I think numbers definitely began to go up. I think there were a lot of approvals, and then you have kind of a feedback loop from that. And the approvals, people say, oh, everything's getting approved. And so we saw more stuff. And then, all of a sudden we started hearing from the service centers like, yeah, this guidance was helpful, but, we're seeing all this stuff. And, I don't think it's a secret if you look at what we issued in very early in 2025, it's very clear what issues were coming up because that's what the policy manual shifted to address. Because this is not a secret I'm giving away. It's pretty clear from the policy manual, given what we addressed in there. They were seeing issues where people didn't qualify for EB-2. And the national interest waiver is something that you can waive, but first you have to qualify for EB-2. Well, now there's a whole section explaining that. And it's not just to be, we didn't view it as being stricter. It was just like, hey, guys, you have to understand what this classification is that you're applying for, what this benefit is. So, and the field needed guidance too, because the field was saying, look, we don't have a labor cert. So we're not seeing what the requirements for the job are. So how do we know if this is an EB-2 job? So, there was really a lot of confusion there. There were a lot of situations where, and again, this is pretty clear from the new guidance that came out, they were seeing cases where the endeavor didn't necessarily relate to what the person had been doing already. And so, there were a lot of issues. So yeah, I don't think it's a surprise that when you see that huge increase in submissions that, approval rates are going to go down a bit because, at least part of what is driving that number, part of it is because we would like to think that part of it is because we explain to people, hey, this is how you can qualify for it. And they say, great, now we know, now we're going to apply. And I think that was part of what drove that. But it also drove people to think, hey, it's a free for all. And so, that came to the attention of OP&S, and that, we tried to say, hey, look, here's what we mean by here's how you can be eligible. We want people who are eligible to apply. We're not trying to dissuade you, but we want you to understand the benefit, understand what it is. And so here's how you can structure your endeavor, structure your petition so you're better prepared to make the case of why you should get a national interest waiver.
Yeah, absolutely. And what I want to talk about next, because we talked about this before we started recording, I know that for NIWs and for EB-1As in particular, is additional clarification that needed to be done through the rulemaking process that you were working on. That has been, we're recording this on January 23rd. There's been a lot of chatter about the notice of proposed rulemaking that supposedly might come out soon, but it's been on the back burner since you were there. But before we do that, I just want to show some data that sort of demonstrates exactly the story that you just told, right? So again, for those who are watching, you can see the chart in front of you. For those who are just listening, I'll orate it. But back in fiscal year 2022, the overall approval rate for the EB-2 NIW I-140 category was 96%, right? Which is like pretty on par with what approval rates are for most of the other employment-based I-140 categories. So Lori, like you said, yeah, there was there's a lot of advantages to the NIW versus the perm-based EB-1/2. Perm-based EB-2. And as someone on the market side, there was a big incentive to push this out to a lot of people. And some of the people who were doing that were not honest actors. And so that contributed to a massive spike in applications that simply weren't qualified. And the decline in the approval rate, I think, bears that out. Sure, was there some confusion, like you mentioned, around what qualifies for an NIW versus what doesn't over this time period? Yes, but there was also just the let's call them like the the market filters, which are typically the law firms who do the first assessment that says, hey, I think USCIS will believe you're qualified for an NIW. That was starting to fail in the overall market. And you saw the approval rate decline to 63% as of the beginning of fiscal year 2025. At Lawfully, we're tracking that in real time. We predict that when the next round of USCIS data comes out, which will cover July through September 2025, the NIW approval rate will be somewhere around 37%, give or take a couple of percentage points. So that's 2 out of every 3 being denied. That said, there are still numerically more NIWs being approved than ever before because there are so many applications. But the overall approval rate, whereas back in the day it was, a couple of years ago it was 96%, is substantially lower now. And a lot of that has to do with sort of the way the market reacted to what they viewed as this opportunity created by some of the ambiguity maybe in the NIW rules back in the day. That certainly is shifting now. There are certainly we showed it in the chart before. The trend line of NIWs that are being submitted is going down. Still a lot though. So, but Lori, on that note, the other thing I wanted to cover before we wrap with you here is this notice of proposed rulemaking. Again, we're recording this on Friday, January 23rd. It'll probably come out next week. But this has been, a lot of folks have been talking about this on LinkedIn. A lot of practitioners have been talking about this on LinkedIn. It's been around since I think the summer or last spring. The synopsis, the abstract for the rule. We don't know what's going to be in it until the proposed rule is published in the Federal Register. But you were telling me before we started recording that like modernizing the I-140s, the I-140 program in general is something that you and your colleagues at USCIS have been discussing and pushing for a very long time. So Lori, maybe you could give some insight on some of the core components that you think might ultimately be in the proposed version of this rule when the text comes out, in terms of modernizing the EB-1A, modernizing EB-2 NIW, and so on and so forth.
Sure, sure. I mean, I will point out first that the unified agenda is always aspirational. So I don't think that this rule being on the unified agenda necessarily means that it's definitely going to happen. I mean, there have been things like the adjustment of status rule that was on the unified agenda for quite some time, and you haven't seen that yet. So, just because a rule appears there doesn't mean it's going to happen. I mean, obviously, personally, I would love to see an I-140 rule. I always argued for one when I was at OP&S because I felt that, that there's a lot that needs to be updated. There's a lot that just is not, doesn't take into account, the modern world. If you look just at E-1-1, I mean, you talk about published material. Well, that reg was written before the internet. I mean, it is to try and cram the internet into that regulation that predates it, that had no, didn't understand how people become famous today or gain acclaim today. It's just, it's not a useful, there's nothing about venture capital in that rule, right? And that is something that's relevant to E-1-1, I think. And people can argue about how it's relevant, but it's certainly, I would say, relevant. And so, there are things that are definitely need to be updated. For example, the talks about album sales and compact discs with a K sales. Okay, this is not something we see for artists anymore, right? So it's not a helpful rule anymore. So those things I would like to see modernized. Also, what I would like to see, if I had my druthers, if I were writing the rule, I would also rework some of the criteria so that they all had a little bit of teeth to them, so that they were all a little, they all were pretty impressive. For example, the display right now, it just says display and an artistic exhibition. Well, can that be at elementary school? Like there's nothing there, right? So if I were going to write the rule, I would try and make all of the criteria, a little bit more interesting and more relevant to showing your reputation in the field, so that without raising the number of criteria you need to meet, when you get to the final merits determination, it's a little safer bet that you're going to pass that final merits determination, because all of the criteria already had a little bit of teeth in them, instead of just something that everybody in your field does. So I think that would be helpful. That would be more clarity, right? People would feel more comfortable knowing, okay, I've met 3. Now at least I have an argument for why I meet the final merits determination, because those criterias were already something to be proud of, to show my reputation. So those are the kinds of things that I would like to see in a rule. Now, whether or not this administration is going to put those kinds of things in a rule, I can't say. I don't know what the thinking is now. But those are the kinds of things that I think could really, make for a better I-140 adjudication. And also, I think, if you really want to say what is in the national interest, rulemaking is how you do it.
Right.
I'm very familiar with the person who wrote NISDOT, and I know it. And I know that decision wasn't perfect, but the thing is, it's very difficult to write a precedent decision that interprets a non-existent regulation, right? And the statute says very little about what is in the national interest. So that's very difficult to write a precedent decision. And Damasar was bound by the same complications. And so really you need a reg. You need a reg to say what is in the national interest. And so I don't know what that would be. I feel like that is an exciting opportunity for some administration, whichever administration it should be, to say, hey, look, this is what is in the national interest. This is, our secretary has determined that this is what is in the national interest. I would love to see that. I would love to have some clarity.
Right.
But what they're going to say about that, I don't know.
And I think that's the big question right now, because again, I'll just share the latest USCIS data on approval rates for EB-1A was 67%. So that was the quarter covering March through June. Again, we track it in real time at Lawfully. We're projecting that when the next round of official USCIS data comes out covering um, July through September, that'll be 53%. It'll actually be a little bit lower than that for October through December. For NIWs, the latest official data, again from March to June, was that 54% of NIWs were getting approved. For July through September, we project it's going to be closer to 37%, so a pretty big drop. Those numbers, the official data is a problem in itself, but the fact that 1 and 2 EB-1As that are being submitted and reviewed by USCIS officers are being denied, and 2 out of 3 NIWs that are being submitted and reviewed by USCIS officers are being denied is a problem that could be solved, like you said, with greater clarity on what qualifies individuals for these. And this has big ramifications. The average processing time for a regular process NIW has gone from about 4 months, 5 months a year ago to 13 months in our latest data, right? For your average processing time. And that's tricky because most of the NIWs, actually almost all of the NIWs that were in premium process that were reviewed this year were filed during the Biden administration in a very different climate, right? Under a different regime at USCIS, creates a
Right.
lot of problems. And there's this isn't a small amount of money that's being thrown around.
Right.
The market value of the EB-1A, EB-2 NIW, and O1 petitions, for legal providers or immigration providers who are filing these cases, is over $1 billion, right? So there's a lot of people who maybe think that they're qualified or are being told that they're qualified. And it's causing backlogs at USCIS because USCIS officers have to read through these 1,000-page petitions of evidence that is a little bit shaky in some cases, and that prevents the next person from their petition being looked at. Like this seems like a problem with, like you said, a regulatory solution to get those approval rates higher, not because like USCIS is scrutinizing petitions any less, but because the market has a clearer understanding of who qualifies for these types of these pathways.
Yeah, no, I think that's exactly right. I think, it should be clear. And that was, there was always my goal with policy manual updates was I want people to understand what they're eligible for and what they're not so that they don't waste their money and their time,
Yeah.
and also that, officers understand so we get more consistent adjudications. I don't think it's any secret. And I think a lot of people have noticed that the USCIS is no longer, well, that they haven't published non-precedent decisions, redacted non-precedent decisions from the AAO since
Right.
March. There's now one NIW from April that somehow snuck through and got on there recently, but basically nothing since March. And that I think is very disappointing because if there is a shift in adjudication when the policy manual hasn't changed, then I think that there's no transparency there why that's happening. And if we can't see, even though the AAO issues non-precedent decisions and they're not binding, the field reads them when they get them back. And
Mhm.
so for us not to see what the AAO is putting out, and I say that as someone who was at the AAO for 17 years, like that bothers me. Like
Yeah.
it should be, USCIS should be transparent. We should see what the AAO is telling the field because that's what the field is following, whether it's
Yep.
precedent or not. And so I don't think we know if the adjudication standards have changed because nothing in the policy manual has changed and we can't see what the AO is saying.
And that's been one of the complaints of many practitioners who I see these posts. I mean, I talk to them and they post about it on LinkedIn quite often where they're like, okay, I got 2 EB-1A decisions back this week for clients. And they'll like list out what the profile of the client was. And they're very, very similar, right? But it'll say, but two different officers, because they have the officer number on the RFE, for example, adjudicated these petitions. And one was denied or one we just got annoyed for, and the other was approved. And like I don't understand why as a practitioner what my takeaway should be in terms of preparing the next EB-1A petition for a similar client in the future or right now, right? And sort of how I should advise clients on who's qualified or not. And so that creates a lot of confusion for them as well, the lack of transparency and like frequent update, like you mentioned, like frequent updates coming from USCIS on like, hey, there's been a lot of questions about this aspect and whether or not, this piece of evidence does XYZ. And those minor updates, like practitioners pay close attention to, obviously, because it is important for their practice and for their clients. And one thing that came out, I know it wasn't necessarily uh, your what you were focused on at USCIS, but CBS News, and we talked with them. We provided them some data as part of that story, but it's been making the round. CBS News did an article on sort of the rise of the industry around EB-1A evidentiary fraud creation or fraudulent evidence creation, right?
Yeah.
What was your experience in the policy shop? Because that's been happening for a long time. I think it's certainly again the industry around it in terms of some of the examples they gave in the CBS News article are well known, but like um, you know, putting names on papers that somebody didn't actually contribute to, or like pay to get them some sort of award or credential that is doesn't really have any weight to it. Was that something that you all were trying to? Obviously, fraud is fraud, but then there's gray areas, right? Where it's like, well, I did contribute to that paper, but how
Yeah.
does that actually qualify me? Was that something that you all were thinking about? Um, at the Office of Policy and Strategy when you were there for EB-1A in particular was like how to deal with some of those gray area examples.
For sure. I mean, it comes up. I mean, our division had, uh, probably still has somebody dedicated to, fraud prevention. So it's something that we look at. And when we hear, concerns from the field that they're seeing a new pattern, that would mostly go to FDNS. So I think
Yeah.
probably FDNS is looking at that more than the Office of Policy and Strategy. But, if it were something that we would need to address by policy, then I'm sure it would come to the policy office.
I have this hypothesis, and I just sort of want you to give me your assessment on the hypothesis as it stands now, because at Lawfully we're trying to collect actual data on this.
Mhm.
But I've heard in conversation, one of the takeaways I've gotten from conversations with a lot of former adjudicators and folks in different roles at USCIS is that and talking with immigration practitioners themselves is that for like the EB-2 NIW, EB-1A, and O1 categories in particular, the petitions that practitioners are submitting are getting like just longer, like more pages of supporting documents than before. And I've had many practitioners tell me the average EB-2 NIW petition that they submit is like 500 to 1,000 pages, right? That means there's many that are more than that. And you and I were talking before about like obviously there's been a backlog created for the NIWs in particular, but now the EB-1As, and we're seeing it with the O's, processing times are going up as well. Um, and you mentioned that some of that was like return to office and the fact that, and I'll let you talk about that in a little bit, sort of what the reality for adjudicators looked like when you were leaving USCIS. But how much do you think like petition length, just purely petition length, impacts overall USCIS adjudication processes? Like, it must slow things down, but like individual adjudicators, I know have goals in terms of like how long they're supposed to spend on each petition, regardless of how many pages each petition is. So, so what do you think about that? Do you like my hypothesis is that all else equal, a longer petition for a qualified candidate is going to give you mixed results compared to a shorter petition where the evidence is very clear, very easy for an officer to digest and issue an approval if it's a qualified petition. You're going to have your better, more consistent chances with that versus the longer one. I guess what are your thoughts on that as someone who has actually been on the inside?
Oh, I would absolutely agree with that. I mean, obviously, submit the evidence you need to submit that
Yeah,
support it. I mean, right? The statute says extensive evidence for E11, but if you're padding it, if you're putting in things that are just going to distract from the better evidence that you're submitting, I think that is not at all helpful, and it makes it harder to find the really strong evidence. So, and also if it's not well organized, that's, a problem too, and it's not tied to anything, that makes it more complicated too. You just submit it and say, look, all this great evidence shows how wonderful this person is. Well, why? How? Tie it to a criterion, tie it to, a prong of NISDA, like explain what you want me to look at this evidence for, I think helps a lot. So definitely don't hide your evidence. Don't pad it with stuff that's irrelevant. That is not at all helpful. And, the officers don't, they have limited time, and they're looking at these on a screen,
yeah.
because they're scanned now, they're electronically reviewed. So they're looking at it on a screen, and, if they have to turn their head like this, that's a challenge. So, the easiest way you can make it for them to be able to scroll through it, see the evidence, see what's strongest, see, and, not pad it with extraneous stuff that doesn't really make your point. I would absolutely agree with that.
This is more of a half-baked idea, but I like to do these every now and again on the podcast with folks who are policy-minded like yourself and have actually developed and executed policy at the highest levels at USCIS. Do you ever consider like putting out I know that there's a lot of complications to this, but like example petitions of like, hey, here's a really like obviously there are a lot of different types of NIW petitions or EB-1A petitions that are approved for a lot of different backgrounds, but like, hey, here's 20 examples for like a doctor and for a pilot and for all of these different professions that we see the highest of like 300 pages, nice and tight, the evidence we like to see for a speedy approval. You guys ever throw that idea around at the water cooler at USCIS?
That's an interesting idea. I mean, I think that there's talk about potential filing tips. And
Yeah.
I know that there is a page And if practitioners haven't found it, they should. There is a page, and it's more buried than I would like it to be, on filing tips specific to petitions that are going to be electronically filed or are going to be scanned,
Yeah.
and it's really good guidance. And the thing is I didn't have anything to do with creating it, but reading it over, I'm like, that these came up because somebody did it. They're like, no
Yeah.
scrapbooks, no action figures. I'm like, who submitted an action figure? That like USCIS is like, please don't submit any action figures. So
Yeah.
I mean, some of
That's
it's silly
crazy.
like that, but it's a good page, I think, and that might help practitioners know what to not bother submitting. 'Cause
Yeah.
that's a helpful page.
I mean, having been an immigration paralegal myself and worked with a lot of immigration attorneys firsthand, and now I talk with many of the folks who file the most H-1B and O-1 NIW petitions on a frequent basis. Like everyone has their own individual, like here's my format that my team uses, right? Because we believe that this is organized, easy for the USCIS officers to adjudicate, and like everyone, every attorney, every partner, every team has like every paralegal for that matter has like they keep their own stats on what their approval rates are, right? Like that's important for their business is to know that
Sure.
there's preparing petitions that are seeing high approval rates. But I wonder if like if USCIS could just clarify like, hey, here's what a clear petition is that our officers across the board can adjudicate quicker, so that we don't have these massive backlogs that are growing and growing and growing. Which again, you can blame USCIS for some of that. I think you can blame the market for more of it, in my opinion. But that's me, sort of turning on my team here. Um,
Yeah.
but
The only thing I could say to that is that, when the AAO was publishing its non-precedent decisions,
sure,
you could see that you could just search for the word, will be sustained, and then you could get. I mean, it's a little tricky with E-1-1s because sustained's gonna pull up a sustained claim, but
yeah,
but you can pull up the decisions that AAO has sustained the appeals, and you can figure that those represent good cases. So I like the idea of having example approvals, but in the absence of that, the AAO decisions would be an
right.
alternative to that.
There should be, yeah, there used to be more resources that would allow you to put those puzzle pieces together. Yeah. Lori, last question for you, because one of the trends I've been noticing again on the market side is as we've been reporting and as the official USCIS data, even though it's lagging, has been showing um, EB-2 NIW and EB-1A approval rates going down. And, sort of the takeaway from that is that it's harder to get either one of those now. It's not necessarily true. Everything, each case is subjective, and there are a lot of smart immigration attorneys who I think are very, very good at doing sort of candidate assessments at an individual basis to determine whether or not that case will have a higher likelihood of approval. And I leave it to them to do that. But the data at a high level has been showing that it's there's a higher rate of denials than there was before, and I'm seeing a lot more marketing around, especially this time of year because it's the H-1B lotteries coming up around the O-1 visa, right? And that being a pathway that more foreign nationals should consider and potentially approve if they were thinking about an EB-2 NIW or an EB-1A. Maybe start with the O-1, even though it's non-immigrant, right? And there are disadvantages to it and limitations around how long. Well, there's no cap on how long you could stay, but you have to renew, and that's a bit of a frustrating like bottleneck for folks. But it's getting more popular. The official data shows that there are more O-1 petitions being submitted. I think when the next round of data comes out, it'll show even more for the summer quarter and the fall quarter. We're seeing it in our data. Um, what do you think, like, what's your projection from USCIS's, or from your experience at USCIS, in how they will handle a spike in O-1 petitions being submitted, given that it's one of the highest thresholds to meet as a candidate applying for it. How do you think USCIS internally will deal with receiving double or even triple the number of O-1 petitions in 2026 that they received in 2025?
I mean, that's kind of an operational question that I think
Sure.
someone from stops would be better prepared to answer. But I will say that, one of the first things that we did when in the Biden administration, when we put out a lot of detailed guidance on O's. So I think that, for people looking to file O's, the policy manual is a really great place to look for, what's going to work and what's not going to work. But how operationally they will handle the increase, hard for me to say.
I guess, do you think that it'll follow a similar story where y you talked about at the beginning of the podcast, um, there are bottom-up issues that get presented to the Office of Policy and Strategy to deal with and to, make changes to the policy manual, if necessary. If an influx of a certain type of O1, cases come in, if we start to see a declining approval rates, which again, for the record, we're already starting to see it lawfully, through our data there are, the O1 approval rates going down, not as nearly as quickly as the NIW or EB-1A approval rate did, but it's starting to tick down a little bit. Um, that the Office of Policy and Strategy might feel the need to um, either change the policy manual to further clarify O1 qualifications. Maybe it doesn't go to because it's just a single visa. Maybe it doesn't elevate to the level of requiring a proposed rule. But I guess, do you see that sequence uh, being something that, from a bottom up level, policy and strategy has to deal with if there's more O1 petitions being submitted that don't meet the same quality standard that USCIS is used to seeing with those petitions?
I mean, I certainly wouldn't rule it out. I certainly could see that happening. I know that. I mean, and obviously, and a regulation that addresses both O's and P's would be, I
Yeah.
think, a blessing to everyone, especially because in the P's we have the Compete Act from what 2008 that hasn't been implemented by reg yet. So I think a lot of people at USCIS would love to see reg, but it's hard to get that on the priority list given the number of O's and P's that are submitted. So,
Yeah.
but
Fair enough.
policy, I could see, that I see that more likely.
Well, Lori, you've been very generous with your time. We could probably go for another couple hours, and we'll have to have you back on soon so we could talk about some of the other topics. We really should do a full EB-5 episode because for any of the EB-5 practitioners out there who listen to the podcast, Lori is someone you should speak to. And on that note, Lori, do you want to talk a little bit about the work that you're doing now and some of the consulting services that you're offering for folks who are listening who might want to reach out?
Yeah, sure. So, I have I started an LLC, 2U's LLC, because there's 2U's in my name, which a lot of people have a little challenge with. Understandably so. So, and what I've been doing is, on a contract basis, I've been helping to draft, cover letters for, E11, NIWs, you know, can do O's. So, any of those, I'm happy to consult on, any of the business related, not H1B, but, other, other business related, issues. I'm, more than happy to consult on.
Awesome. Well, we'll put your details in the description of the podcast so folks can reach out to you if they're interested in working with you, which I highly recommend because I've had the great opportunity to talk with you now a couple of times, and you are a wealth of knowledge. Well of knowledge. I don't know what the metaphor is, but you're both. You're a well of knowledge and a wealth of knowledge on all
Thank you.
things USCIS, EB-1A, EB-2 NIW, and EB-5 and more. So P's and Q's too. Don't forget about P's and Q's.
And ours.
So yeah, and ours. Yeah. So, Lori, thank you so much for coming on. This has been a great conversation. And again, we'll have
My
to have
pleasure.
you on again soon. Thank you.